We will start with State of Indiana versus Katherine Curtis, cause number 29 DO3 2510 F2 9218. State appears by Deputy Prosecutor Megan Singleton. Ms. Curtis appears by counsel Francine Rowley. Ma'am, are you Katherine Curtis? Hold on, the volume is off at the video or at the jail. You can turn your audio on, please. Okay. Thank you. All right. Thank you. And okay, Ms. Curtis, thank you. Ms. Curtis, were you present for the video that was played where the rights you have in a criminal case were explained and the potential penalties that could be imposed?
Yes, ma'am.
And did you understand that information?
Yes.
Okay. Did you get a copy of your charges?
Yes, ma'am.
All right. Ms. Rowley, does your client need a formal reading of the charges?
No, Your Honor, we waive.
All right. Ms. Curtis, if you look at those charges for me, the name, address, and date of birth information, is that correct for you?
Yes, ma'am.
All right. Do you intend to hire an attorney?
Yes.
Have you hired anyone yet?
My dad arranged an attorney, but he hasn't entered in his appearance yet.
Okay. But you do intend to hire counsel. All right. All right, Ms. Curtis, I do want to advise you that you have been charged with a felony in this case. That makes you a prohibited person in the state of Indiana. And what that means is you cannot carry a gun. Do you understand that?
Yes, ma'am.
Okay. I am finding probable cause for your arrest and entering a preliminary plea of not guilty. State, do you have a position on bond here?
Yes, Judge, thank you. While her IRAS score came back as low, we would point out that she did not provide a collateral phone number and she's only been at her current residence for 6 months. We'd also point out that she has owned the business for 10 years that she is alleged to have been abusing to fraudulently obtain prescription drugs. We would point out for the court that given the allegations in the probable cause affidavit of drug dealing, abuse of her position and her license, abuse of the pharmacy system, as well as victimizing her patients, employees, and coworkers, the state believes she poses a high risk to the safety of the community. Additionally, the allegations of taking steps to circumvent pharmacies that would not fill prescriptions submitted under her own DEA number, those allegations, we believe, show disdain for the state's authority with her license and prescription medications, and that gives us concerns that she will not abide by court orders. We would request that any bond that she posts include a condition that she not actively prescribe controlled substances and that she only personally possess controlled substances with a valid prescription. We would also request that the court order her to surrender her passport if she does post a bond. And then we would recommend that bond be set in the amount of $1 million, cash or surety, with those conditions.
Thank you. Ms. Rowley?
Yes, Ms. Curtis does have a low IRAS score. She did give contact information, although her most recent residence has only been 6 months. She has been a resident of Hamilton County for over 2 years. And she has had steady employment for over 10 years. She has no prior criminal history. She is financially responsible for 2 children. She has been a model citizen up until the most recent charges against her, which are alleged incidents that until she's proven guilty, she is alleged innocent. I did speak with her about the no contact orders, and she has no problem abiding by the no contact orders. While she is incarcerated, she has no way to garner income, so a $1 million bond would be an extreme financial hardship to her at this time. We don't believe that she is a flight risk. We believe that her ties to the community are strong, and we'd ask that her bond be set at a more reasonable amount. The highest charge was a level 2 felony. I understand there are quite a few charges against Ms. Curtis. We'd ask for bond to be set at this time at no more than $100,000 cash or surety.
Okay, thank you, Ms. Riley. Okay, Ms. Curtis, the pretrial assessment summary does show you with a low IRAS score. The address, there's not a lot of time there with the address. However, it does appear that you've at least been in the area 10 years, as that's the amount of time it shows that you've had this business. As stated by the state as well as your counsel, I don't see where you have any criminal history. However, considering the nature of the charges, the level of the charges, and the amount of the charges, let's see, there are 31 counts here. I do think a bond is appropriate. You're not an appropriate candidate for pretrial release. I think that the information that the state mentioned does demonstrate to the court that you're a danger to the community. Again, so I think a bond is appropriate. So I am going to go ahead and order the conditions that the state has asked for. Number one is to surrender your passport. Number two would be that you are not to actively prescribe anything to anybody. And you are not to possess any controlled substances unless you have a valid prescription for those substances. The bond amount here, I'm going to set at $200,000 cash or surety. Do you have any questions, Ms. Curtis? Okay, thank you. That concludes your hearing.
No.
Good morning. Our record will reflect that we're here in cause number 29D032510 F69305. This case is entitled State of Indiana versus Katherine Nicole Curtis. Are you Katherine Nicole Curtis?
Yes, sir.
Thank you. Ms. Curtis appears in person. Mr. Becker, you're here, seated beside Ms. Curtis. Are you intending to enter an appearance in this case?
I've been in communication with Katie and her family. I've not entered an appearance yet, so I may be, depending on what financial situations we can arrange.
Okay.
But I'm here on behalf of her today.
So you're here at least today, representing
Yes, Your Honor.
on a limited basis. Thank you. The state is here by Mr. Yeoman, Mr. Harris, and Mr. Coker. Good morning, gentlemen.
Good morning, sir.
Ms. Curtis, this is an initial hearing to advise you that a criminal charge has been filed in this court. It is a 6-count information. A copy of the information is laying on the table in front of you. If you look at the first page of the information, please. On the left-hand side, underneath your name, is an address. Is that an address where you can receive mail and be notified of future hearing dates?
Yes, sir.
There is a date of birth. Is that the accurate date of birth for you, ma'am?
Yes.
And you are charged with 6 counts. They are count 1, fraud.
Judge, we would waive a reading. She's got a copy, and so we waive a reading of the charging information.
Thank you. Then the count 1, 2, 3, and 4 are level 6 felonies. If you are convicted on these offenses, the maximum penalty that can be imposed as to each offense is 910 days in a place of imprisonment and a $10,000 fine. The minimum penalty that can be imposed for each of these offenses is 180 days imprisonment and no fine. In addition, in counts 5 and 6, you are charged with a misdemeanor. Upon conviction for an A misdemeanor, the maximum penalty is 1 year imprisonment and a $5,000 fine. There is no minimum penalty. In addition, the counts 1, 2, 3, and 4, should you be found guilty of those offenses, the court does have the authority and may alternatively enter a conviction and a sentence as an A misdemeanor. So as to each of those cases, in addition, you could receive a maximum of 1 year imprisonment and a $5,000 fine if you received alternative sentencing. Do you understand these potential penalties?
Yes, sir.
Does the state wish to be heard on the issue of bond?
We do, Your Honor.
I'm listening.
Thank you. We believe there are 3 aggravating factors that the court should consider when setting bond under this cause number. First, pursuant to IC 3533.83.8B2, the defendant is released on bond currently for a factually unrelated matter under cause number 29D032510F29218. Second, the defendant's habits and behavior as alleged.
That bond has been posted in that case?
It has, Your Honor.
All right, go ahead.
The defendant's behavior and habits, as alleged, at least shows a pervasive criminal thinking in her life. The court can consider that under IC 3533.84B4. And finally, Judge, her behaviors show a clear disdain for authority, both the police in this instance as well as insurance, which indicate a likelihood or at least the strong possibility that she'll have issues with the court's authority. Court can consider that under IC 3533.84B10. Accordingly, the state is asking for $10,000 as a bond, as an elevated bond. We believe it should be cash, Judge. Surety bond doesn't appear to be appropriate here given this defendant's unique and novel disdain for contractual authority.
So you're asking a bond of what?
$10,000 cash.
10,000 cash?
Yes, Judge.
Mr. Becker, do you wish to be heard?
Yes, Your Honor.
I'm listening.
Katie has never been convicted of any criminal offenses. She did post bond on the unrelated case here in Superior 3. We would request that she be released under that bond. Additionally, Your Honor, she's been a resident of Hamilton County for the past 2 years, so we don't believe there's any fear that she will fail to appear for any court hearing.
Has there been an evaluation performed by pretrial services? These cases fall within pretrial services.
Your Honor, I don't know.
As of this morning, Your Honor, there was no record of that on the CCS. So if it has happened, I don't believe the parties have been noticed.
I'm aware there's no record of it on the CCS, but the court is going to go with standard bond in this case. $25,000 cash or surety will be the standard bond, and that is my order. However, Mr. Becker, if your client wishes to be reviewed by the pretrial services, I frankly would prefer that, and we can arrange for her to be reviewed by pretrial services if she puts the qualifications for placement in that program for all reasons other than the bond she's already posted. I would prefer that she be on pretrial services because then I will have regular, consistent contacts by somebody to make sure that she is still around. And I will require enhanced supervision.
Judge, we would request that.
Okay. So, Mr. Harris, the bond is going to be $25,000 cash or surety. And she may post pursuant to pretrial services so long as the pretrial services program places her, at least to begin with, on enhanced supervision.
Understood, Judge.
Then the preliminary plea of not guilty is being entered on your behalf. It becomes a formal plea of not guilty 20 days following today's date, without further action by yourself. There are conditions of your release on bond or pretrial services. Those conditions are as follows. 1, compliance with all conditions of bond that have previously been imposed against you in cause number 29D03 2510 F2009218, including the specific conditions added in addition to the general conditions. The general conditions also apply in this case. Those are that you be and appear in court at all times required of you. Your next court appearances will be given to you in just a moment. Do not be arrested for, charged with, or convicted of another criminal offense without, during the period that you are gone or released from this court. Do not leave the state of Indiana without prior written permission from this court. Keep your attorney, when retained, and the court advised of your whereabouts. You can be reached by telephone or by letter to advise you of the status of this case. Do you understand these conditions, ma'am?
Yes, sir.
Ms. Curtis, I have a phone number for you ending in 8154. It's indicated here that that's a home number. Is that a home number or is that a cell number?
It's a cell number, but it's the phone number that's tied to a cell phone that's in evidence.
It's a what?
They've taken her phone as a part of their evidence, Your Honor.
So she does not have an active cell phone.
I do. I just have to write it down. So I know what I know.
Your Honor, the phone number that she would be associated with is 463-203-7121.
Wait a minute. 463-20.
3-7121.
Can I repeat that to you, sir? 463-203-7121. And that is a cell phone?
Yes.
Ma'am, do you have an email address?
Yes.
May I have your email address, please?
It is kcurtis061291.
Curtis.
061291
061299
91.
91 at Gmail. Ma'am, notifications are sent by the court via email. If you have an email address on record, and notices are sent to you directly. In addition, you will receive telephone reminders at the cell number that you've given us of hearing dates. You'll receive them a week before the hearing, the day before the hearing, and if there's any change during that period of time. Court is setting your next court dates as an omnibus date with a pretrial at 1:45 p.m. That is on January 13th of 2026. You have a jury trial set for May 19th, 2026 at 9 o'clock in the morning. A final pretrial conference on May 4th, 2026 at 3 o'clock in the afternoon.
Judge, I apologize. What was the omnibus date?
What?
What was the omnibus date, Your Honor?
January 13th of 2026.
Thank you, Judge.
Now, do you have any questions? Mr. Becker, do you have any questions?
No, Your Honor.
How about you, Mr. Harris, or Mr. Coker, or Mr. Yeoman?
No, Your Honor, nothing from the state. Thank you.
That will conclude our hearing. The defendant is remanded to custody of Hamilton County Sheriff pending the posting of bond or pretrial release.
You wanted us to do an order, right, Judge? An order from the state? You are? All right.
Thank you.
Thank you.